A very warm welcome to all. Today, I, Reeya Khanna, a legal intern under LEXIS and Company, am here to explain my topic on case analysis on A.K. Gopalan versus State of Madras, 1950, All India Record 27. Let us understand what this case is about. It is one of the most common and known cases. This is the first case held by the Apex Court in which various articles of the Constitution of India contained in the chapter on fundamental rights were discussed. The main articles were Article 19, Article 21, and Article 22 were dealt deeply within this case. Nearly after 30 years of this case, the Apex Code did away with the restrictive view of the rights embraced therein by the Menka Gandhi versus Union of India. Nevertheless, for the jurisprudence of fundamental rights in India, it still makes an important part of the evolution. The most conspicuous feature of this case is its dissenting verdict given by Justice Fazl Ali, one or two dissenting judges in a six-judge bench. The dissenting judgment given by him back in 1950 went on to become an example of personal liberty and liberalized viewpoint for the fundamental rights. Let's understand the case facts of this case very briefly. In this particular case, the petition was made by Mr. A.K. Gopalan under Article 32, Clause 1 of the Constitution of India, in pursuance of an order made under the Preventive Detention Act 1950. A writ of habeas corpus was filed against his detention. Mr. A.K. Gopalan was a communist leader, and since December 1947, he had been under detention. As imprisonment under ordinary criminal laws, he was convicted and sentenced. However, these convictions were overruled by the court. A.K. Gopalan, when detained on 1st March 1950, was served upon an order by the state government made under Section 3, Clause 1 of a particular act which confers upon the state or the central government. After then, he challenged in court the legitimacy of the order under this act on the ground that the act violates human fundamental rights as provision given under Articles 13, Article 19, and Article 21, and the provision of this act of Madras state are not in conformity with Article 22 of the Indian Constitution. Mr. Gopalan also contended that the order issued was malified. Now, let's understand the issues behind the case. The first issue was whether the Detention Act of Madras State contravened the provisions of Article 19 and 21 of the Indian Constitution. And number two, whether the State's Detention Act 1950 provisions in accordance with Article 22 of the Indian Constitution. Now, in this case of A.K. Gopalan versus State of Madras, it was held by the majority judges that punitive and preventive detention were outside the ambit of Article 19 of the Constitution of India, and hence the Preventive Detention Act 1950 had not violated it. It was also contended by the court that the said article, which provides protection to citizens who are free, therefore not the citizens whose freedom is restrained by law, and the question of enforcing Article 19, Clause 1 does not arise. The Preventive Detention Act 1950 has followed the valid procedure as in form enacted by the state's law, and therefore the Apex Court came upon the argument that it does not infringe upon the rights under Article 21 of the Indian Constitution. Various provisions of the Preventive Detention Act are covered under Article 22, and those which are not are added to the aspects of Article 21. The Apex Court held that Section 3 of the Act was justified, and as it was valid to provide such discretionary powers to the executive, in addition, with the majority court also agreed upon the validity of Sections 7 and 11 of the Preventive Detention Act. Under Article 2, Clause 7, Clause B, the Parliament has not mandatory power to set a minimum detention period, and under Article 22, Clause 5 and 22, Clause 6, the right to representation, which ought to be heard verbally, are not necessary. Section 14 of the said act was also declared ultra vires because it contended the court's right to determine the validity of detention. Now, let us understand the judgment of A.K. Gopalan versus State of Madras in detail. It was held by the Supreme Court of India that any of the sections of the Preventive Detention Act has infringed the provisions of Part 3 of the Constitution, barring Section 14 of the Act, restricting the declaration of the grounds of detention. Section 14 of the Preventive Detention Act was declared ultra vires. Nonetheless, the declaration by the court did not affect the validity of the Act as a whole. Now, let us understand the dissent opinion. The important dissent was given by Fazl Ali, as he said that the court, when analyzing fundamental rights violations, need to coordinately interpret the various articles under Part 3 of the Constitution of India and not merely as silos. Further, Section 12 and Section 14 of the Act, while contravening Article 22 of the Indian Constitution, were also contended to violating freedom and personal liberty of the individual. Moreover, Justice Mahajan differed in his conclusion and holding Section 12 to be ultra vires while agreeing to the majority judge's interpretation. That is all for today's video. Now, thank you so much.